Hi, thanks for tuning in to another dose of bite-sized bits of knowledge where we give you meaningful information in a short amount of time. Today we're talking about customer agreements, what they are and why should you care. So customer agreements, in our experience, are something that for some reason most businesses don't do, and they don't do well. In our experience, many business owners don't have one, and the ones they have are less than desirable. There's a lot of things to improve in them, and we make those recommendations. So let's tell you about what some of those recommendations are that we would see, or some of the things you'd want to see in a quality customer agreement. Now, it doesn't matter whether you're an artist creating, logos and websites, or you're a software developer, or you're a lawyer, you're a plumber, electrician, you're a roof inspector. It doesn't matter. The concepts are the same. You want to understand who the parties are, who is contracting who has rights to the agreement and the terms of the agreement. What are the obligations that each party's promising? So generally in a contract, you got to have, offer, acceptance, consideration. If you go back to law school, offer, acceptance, consideration. Well, what's the consideration? Consideration is something of value. This doesn't necessarily have to be money, but it's something of value. The courts don't interpret what value is as long as both parties are getting something of value. So if you're performing a service or you're creating a product, then you're probably going to get money or something in return for that product of similar value. And that needs to be documented so it's very clear what those things are. If you're creating a product, you're performing a service, either way, you should have a timeline of what you're doing, when's it going to be done, when can it be expected to be delivered, how it will be delivered. If it's like intellectual property, for example, is it email? Is it a link? Is it what kind of files is it? If it's a logo, is it the PDF file? Is it the other AI file, the Adobe Illustrator files? Is it the file? There's a lot of different kinds of files that matter. That would be something to think about when you're giving deliverables. I would say it's really important to limit scope. Limit scope to what you're doing and what you're not doing, to identify very clearly what the expectations are. In software development, for example, it's really easy to say, here, let's do this. We're gonna do this, here's the contract. And then customers say, well, can you just change this and maybe change that? And then the next week it's this and that. And before you know it, your scope has really tremendously increased and your compensation hasn't. That's called scope creep. It's a very common term for where customers kind of, sometimes I would say they do it, they don't do it intentionally to be mean or take advantage, but it just happens. But sometimes people do take advantage. And in either case, you're welcome to, of course, increase your scope without compensation. But I generally would say, the customer needs to understand that what you've done exceeds scope, and they should appreciate that, or at least be compensated for it. So scope creep is a real thing, and you should be careful to document exactly what you're doing and what you're not doing. So think about also what compensation is being given. When is that compensation being given? How is it being given? Is it a wire? Is it a check? When is it being given? Is it 1/3 on signing, 1/3 on deliverables, and 1/3 on approval? Is it half up front, half later? Just think about many things that can go into that. I would also add that these contracts need to have relief and remedies of when things go wrong. When things go wrong, what happens? What rights do the parties have? So the first thing you'll notice in a good contract is there will be something relating to conflict. Sometimes you'll see things called alternative dispute resolution clauses, ADR clauses. Sometimes you'll see mediation, arbitration, or litigation. Mediation is generally non-binding, and it's just an opportunity for the parties to kind of communicate with one another and then communicate separately with a neutral person as a mediator and see if a deal can be worked out amicably, because as you'll learn later in the litigation videos, litigation is very expensive and time consuming, and nobody wins. Mediation is a great first step if you just can't resolve things. Arbitration, on the other hand, can be binding or non-binding depending on the agreement. Litigators typically don't like arbitration because it limits, access to the court system and rights and remedies, and it's just I've heard lawyers that love litigation, arbitration, and I've heard litigators that would hate to have an arbitration clause. So you just got to understand what they mean, some of the pluses and minuses about them. But at the end of the day, these are vehicles of conflict resolution in a more economical, practical way. So arbitration, usually there's one or more arbitrators where each party puts on their case. They go through the motions of getting information and facts, and then an arbitrator decides, like a judge. But the arbitrator decides it's more of a private resolution. And as I said, it could be binding or non-binding. Litigation, of course, I'm gonna have a whole video dedicated to that. That's going through the court system with or without lawyers, and it can be very expensive. So that's usually something you want to see in there. In terms of miscellaneous provisions, I think that miscellaneous provisions is one of the most overlooked and undervalued part of a contract. It gets missed all the time. These things are important. You'll see things like the ability to amend the contract, restrictions on amendment, restrictions on assignment. Assignment means assigning of rights. It could be delegation of duties. It's important stuff. You don't want to get in a contract with somebody who then assigns it to somebody else, and now you're kind of working with somebody else who you have no idea is qualified. Think about attorney's fees. As I mentioned, litigation is expensive, and primarily because of the attorney's fees. So if you put in there a fee shifting provision, that raises the stakes, much like in backgammon when you have a doubling cube. The stakes could be whatever they are, 25, 50, 100,000. Okay, lawyers' fees will be that much too. And that deters the parties, or is intended to deter the parties from really going to war, because someone's going to be holding the bag of liability as well as the other person's fees. And so it's like the doubling cube in backgammon. It's a significant deterrent. Jurisdiction, venue, where the case is going to be held, in what county, that matters. If you're going to fly across the United States to litigate something, that might deter you as well. These things matter. These things are important. Integration clause, that just basically means that the contract is on the paper, on the four corners of the paper, is the agreement between the parties. What you told them last week, what they told you last month, what they promised you yesterday, and what they're going to promise you tomorrow doesn't matter. What's in the contract is all that matters. That's very important, because if that's not there, then there's a he said, she said, oral contract, verbal contract, and verbal contracts can be valid and binding, which creates more facts, more conflict, more resolution of issues later. So customer agreements really need to be buttoned up tight. They identify the parties, the compensation, scope, deliverables, rights and remedies, miscellaneous terms. If you're serious about your business, you need to have a customer agreement that's good and reflects the professionalism that you're giving people. You don't want to have a really nice professional brand and then give them Mickey Mouse contracts. That doesn't look good, and that's not respected. So I hope that you found this helpful. Thank you for stopping by. Don't forget to download our free business planning stress test. It's linked below in the description, and stay tuned for more.
Hey